All right, bailiff, can you take the jail court off of mute, please? All right, good afternoon, Mr. Sanders. How are you?
Doing fine, Your Honor. How are you today?
I'm doing fine. All right, court call CR 2150, State versus Judson Taylor Brown, set for docket call today. Is that correct?
Yes, Your Honor, that's correct.
And go ahead.
Oh, Judge, I was just going to ask if we could have it. I believe this was the first docket call. If the court would allow, we'd like to have it set for one more docket call, see if we can get something worked out with the state on this matter.
All right, let me double check. I show that this is the fourth setting. Let me see where we're at. What's the while I'm looking, what's the current offer, Mr. Brown?
It's 12 years TVC. And Judge Park, he has one or two cases, 2 felonies pending in Dallas County. I tried to get a hold of his attorney in Dallas County just to at least see potentially how things might be getting resolved there, because that could potentially have an effect on how it gets resolved here. But I would just ask for one more docket call and see if we can't get something resolved on it.
I show today is our first setting for docket call. Is there any objection from the state?
No, Your Honor.
All right, I'll give Mr. Brown one additional docket call, and then at that time, Mr. Sanders, I'm going to need to know, are we going to trial or are we going to resolve the case?
Okay.
We're going to set this for docket call on January 5th in the afternoon at 1:30. All right, Mr. Brown, we'll see you back on January 5th.
Thank you, Judge.
Is that all you have, Mr. Sanders?
Yes, it is, Your Honor. Big excuse.
Yes, if I don't see you again, Merry Christmas.
I'll see you on Thursday. But Merry Christmas to you anyway.
Well, I'll tell you Merry Christmas again on Thursday then.
All right, sounds good.
Your Honor,
Yes, ma'am.
we do have Christopher Fields outside. If Mr. Sierra's ready and you are agreeable to that, can I bring him in?
Yes, and he's going to be a plea today. Is that correct? Here we go.
What I understand, yes, sir.
Yes, let me bring Mr. Sierra in tomorrow.
Good afternoon, Judge.
Good afternoon, sir. How are you?
Doing good, Judge. How about yourself?
Doing well. Now, prosecutors, I don't have any signatures from any prosecutor on these.
Judge, I'm sorry. Let me make sure I gave your court the right copy.
Is this just a copy for me to refer to and you have the original maybe?
Yes, that's correct, Judge. Yes, I have the original here. It's been signed by myself, the defendant, the defense attorney. We just need to get a fingerprint on this one.
Okay, that's fine. All right, Mr. Fields, this is cause number CR 20-158. Christopher Sean Fields. Are you Christopher Sean Fields?
Yes, sir.
Mr. Fields, if you will, raise your right hand, sir. I'm going to place you under oath. Mr. Fields, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Make sure you speak up loudly and clearly so my court reporter who's here in the courtroom with me can take down your testimony, okay?
Yes, sir.
Okay. And Mr. Sierra, can you see and hear your client okay?
Yes, Your Honor.
Mr. Fields, can you see and hear your attorney, Mr. Sierra?
Yes, sir.
Okay. All right, Mr. Fields, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Rafael Sierra. Are you pleased with his representation of you?
Yes, sir.
And do you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've signed and reviewed that you do not understand?
No, sir.
And Mr. Sierra, do you believe Mr. Fields to be competent today?
Very much so, Your Honor.
And you've explained to him his legal and constitutional rights.
Yes, Your Honor.
Mr. Fields, you are charged by indictment with a third-degree felony offense of unlawful possession of a firearm by felon. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And it appears to me that there's an agreement in this case wherein you would plead guilty to that charge in exchange for the state's recommendation that your sentence be assessed at 8 years confinement in the Texas Department of Criminal Justice with a dismissal or consideration of an unfiled DWI and also a weapon forfeiture. In addition to that, you would have court costs of $290 and reimbursement fees of $35, and you would receive 2 days credit towards your sentence. Mr. Fields, is that your understanding of the plea agreement?
Yes, sir.
Yours as well, Mr. Sierra?
Yes, Your Honor.
All right, at this time, Mr. Fields, I would ask you, how do you plead to this charge?
Guilty.
Mr. Fields, are you pleading guilty to this charge because you are guilty of this charge and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty, Mr. Fields?
No, sir.
All right, the court will accept Mr. Fields' plea of guilt. Mr. Sierra, is there any objection to the admission of the stipulation of evidence as State's Exhibit 1?
No objection from the defense, Your Honor.
All right, court admits State's Exhibit 1, stipulation of evidence, and takes judicial notice of Mr. Fields' judicial confession. Is there anything further from the state?
No, Your Honor, rest and close.
From the defense?
Rest and close, Your Honor.
All right, thank you. Just one moment. I'm going to review the stipulation. All right, Mr. Fields, based on the court's review of the evidence, the court will find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement in your case. The court hereby assesses your punishment at 8 years confinement in the Texas Department of Criminal Justice Institutional Division. The court assesses a zero fine, orders you to pay $290 court cost, $35 reimbursement fee. The court takes into consideration under section 1245 of the Texas Penal Code, unfiled misdemeanor cause M19908, a driving while intoxicated offense, and the court orders the weapon seized in this offense to be forfeited, that being a High Point 45 ACP serial number 4271917. Mr. Fields, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. Good luck to you, sir.
Thank you, Mr. Fields.
I'll have you step to your left with the bailiff to be fingerprinted. Mr. Sierra, anything further at this time?
No, Your Honor. All I ask if I have permission to be excused.
Yes, sir, you do. Thank you very much.
Thank you, sir. Have a good day.
You too.
Your Honor, the transport officers have gone to retrieve one of Mr. Murleader's clients. Should be back shortly with them.
Okay, thank you. All right, Mr. Murleader, who do you have with you?
Judge, this is Miss Georgie Walker.
Cause number CR 18231. Ms. Walker set today on motion to revoke.
That's correct, Your Honor. We have received a offer from the state of 15-month state jail with the unindicted ag assault with a deadly weapon to be taken in consideration of that plea under Texas Penal Code 1245. We would request more time to consider that, Your Honor. I received that offer from Ms. Heisel yesterday, and I've already conveyed it to Ms. Walker and asked her to consider it. In the meantime, Judge, I need to also put on the record a few things. Ms. Walker has asked for an MHMR court. I've already explained to Ms. Walker that I can't file for an MHMR court because there is none in Van Zandt County. She's not entitled to an MHMR court here in Van Zandt County. I'm not sure, if Van Zandt County has enough of the population where OCA requires an MHMR court, but I don't think it crosses that threshold yet.
What are the MHMR issues that Ms. Walker believes that she needs a specific court to address?
Your Honor, I believe she has, a few mental health issues for which she is getting medications for, including bipolar and depression. She says she's taking medication for those now. When she was in Henderson County, she did go to their MHMR treatment center and get medication from there. And she's explained to me that she's also gone to the Canton Andrews Center. I've requested records for both of those places, so I'm awaiting that. But those are the issues that she feels needs to be addressed at an MHMR court.
That she's received medications from the Mental Health Authority?
Yes, for bipolar and for depression.
What is it that she needs the court to address? The fact that she is getting medication as she's requesting? Is there an issue for the court to address?
Well, no, Your Honor, she believed that she had the right to file for an MHMR court, like a mental health court,
Your
to
Honor,
have our case done.
if the court recalls, a couple of weeks ago, Mr. Green's client, Ms. Red, she seemed to be under the same impression Ms. Walker is, that she was entitled to be transferred to an MHMR court, which as Mr. Murleader pointed out, doesn't exist here. Does that ring a bell at all?
Yeah, it does, and I understand the request. And as Mr. Murleader has pointed out, there is no MHMR court in Van Zandt County. But I need to know what issue. I just want to know what issues meaning there's a problem, and there has to be some kind of addressing of a problem to reach some kind of resolution as to what the MHMR request for court is. So what you said, Mr. Murleader, is that she wants a court to address that she has requested medications from two different authorities and has received those, one in another county and one in this county. Is there an issue that the court is to resolve regarding MHMR, or or are you arguing that this is something that should be mitigating in the motion to revoke hearing, which we're not having today?
Judge, frankly, I don't know the answer to that question. I can ask my client that, why she specifically wants to be in MHMR court, but I really don't know the answer to that.
I just need to know if there's an issue that I need to address, such as if she were not getting her medications as requested and she was diagnosed with having a mental health disorder that was causing her to suffer in custody. That would be an issue that I would need to be aware of and could possibly help with address. But at this time, I haven't heard an issue that the court should address other than just acknowledgement that she's been diagnosed and that she's receiving the treatment that she's required.
Okay.
Do you want to step away and speak with her and then come back?
Yes, Judge. Let me ask her what she wants out of that, and I'll address the court.
Thank you, sir.
Mr. Murleader, I'll mute this.
Go ahead, Mr. Marketer.
Judge, Ms. Walker is not aware of anything else that an MHMR court can do at this point. You know, she stated to me that she would like to have an MHMR court take into account that she has these issues. And at this point, she doesn't know what kind of resolution an MHMR court can give her other than what I've already explained to the DA's office about her medical history. So I don't know if that answers the court's question.
So what I hear is that she has a diagnosis of a mental health disorder, that she believes that that's important for the court to be aware of, and that you, as her court-appointed counsel, has brought that to the court's attention, and that if those mental health disorders you believe are some type of mitigating evidence, that you'll have that information, and if you choose to present that, can present that at the motion to revoke hearing if one is held. So at this point, I believe that we have satisfied all of the requirements, if we had any, to address the MHMR aspects of Ms. Walker. So is there any objection from the state? I believe Mr. Merleader is asking for an additional motion to revoke setting, and I'm not sure how many we've had. I'm going to look into that, but is there any objection from the state?
No, Your Honor, because I did just make a new offer yesterday, I have no objection to him resetting and talking to his clients about the pros and cons of that.
All right, Ms. Walker, the court is going to grant you one additional hearing on your motion to revoke. And what I'm going to do, Mr. Merleader, is I'm going to go ahead and set this on the contested docket date of January 28th, so that if there is no resolution between Ms. Walker and the state, we'll proceed to a contested hearing on the 28th of January.
Yes, Your Honor. There's a few additional things that I just need to put on the record, if the court will allow.
Go ahead.
Judge, Ms. Walker has accused me of not working for her and explained that she's entitled to a bond reduction. I've explained to her that because I'm court appointed and she's indigent, I'm not going to file for any kind of bond reduction. And I just wanted to make that plain and clear to her and the court that I'm not filing for any bond reduction. If she wants to go hire an attorney, she can certainly do that, and they can file a bond reduction if they wish to. And she also has asked me, if the indictment for the ag assault with a deadly weapon is not filed in 90 days, would that be dismissed? And I'd explained that she might be eligible for a PR bond subject to the governor's emergency orders, but the state is the one who's going to determine whether or not to dismiss that. And that case is offered to be taken into consideration with the current plea offer. And if Ms. Walker wanted to address the court about any deficiencies I had that she may be thinking about, she's free to do so, Your Honor.
Ms. Walker, do you want to discuss any issues you're having with Mr. Merleader at this time?
I was just asking him to give me a bond reduction so I could be out for Christmas. But he wouldn't, he didn't think of it, but that's it, Your Honor.
No other issues?
No, sir.
Ms. Walker, was one of your alleged counts in your motion to adjudicate that you failed to report
Yes, sir.
on one or more occasions?
Yeah, just served one on one occasion.
Yeah. So I would tell you the court's not inclined to grant you, even if Mr. Merleader filed one and zealously argued for it today, the court's not going to be inclined to grant that. So that you're aware. You understand?
Yes, Your Honor.
All right. So We're gonna come back on January 28th, and if you have reached an agreement with the state to dispose of your cases, we'll do so on that date. If you haven't, then we'll move forward with a contested hearing, and the state can present their evidence, and you can present yours if you have any.
Yes, Your Honor. Thank you very much. I'm just used to it. That's the original. Okay, gotcha. Yeah, that's correct. Right.
Wait, is he going into custody? Autry, is he going into custody?
We're fixing to tweet it now.
Do you have paperwork?
She's getting it,
Oh, okay, okay.
getting it to Stephanie, and 1244A, and even getting it done down the road.
No problem.
All right, Mr. Murray Leader, is this Mr. Lennox?
That's correct, Your Honor.
All right, this is cause number CR 2133, State of Texas versus Micah Floyd Lennox. Mr. Lennox, if you will, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. All right, Mr. Lennox, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
With schizophrenia, bipolar, and severe depression.
Are you on medication for any of those today?
Yes, sir. For panic attacks. Just I'm allergic to antipsychotics, so but just for panic attack, I take a panic attack medication daily.
Okay. And do you believe that medication is assisting you today and giving you rational thought and understanding?
Yes, sir. Yes, sir.
Do you feel like you understand the proceedings as they have occurred in this case and are occurring today?
Sir, I've done my best. Yes, sir. Trying to.
Is there anything up to this point that you have not understood?
Yes, sir.
All right. In this case, you're represented by your attorney, Mr. Shavnesh Muraliter. Are you pleased with his representation of you?
Yes, sir. Yes, sir.
You kind of shrugged your shoulders. I need to know clearly, are you pleased with his representation of you?
Sir, I've had some confusions here and there. I'm just had some confusions, and I'm just faced with the factor of going ahead and signing now, and so that I don't get 50 years day for day on top of me. And yes, sir, I just want to get through this. Yes, sir.
Is there the confusion that you have? Have you addressed this confusion with your attorney?
Yes, sir. I was mistaken, if I am mistaken, and was hoping he could help me more with understanding how, if I could have got a lesser sentence, could I? It was always told he cannot do anything. He cannot do anything. He cannot do anything. And they dropped it. Thank goodness for the grace of God, dropped me to where I can be eligible for parole. So I just have been confused about, if you can't do anything, then I do know, I understand I do have to need to have an attorney to represent me. It's just been a little confusing, but I'm here to sign. Yes, sir.
Mr. Murray Leader, can you shed some light on any issues that you believe that Mr. Lennox has had regarding the confusion that he's citing?
Judge, I think that Mr. Lennox is basically asking the court, if he could have gotten a lower plea, he would have gotten it, right? I explained to him that he's charged with continuing sexual assault of a child, which is a 20 federal life case, and if convicted, the minimum punishment he would receive is 25 years, day for day, without parole. And given the evidence in this case, given the confession, and given the witness testimony that would be presented at trial, I explained to him that we would most likely be found guilty beyond a reasonable doubt if we had proceeded to trial. And the plea offer that we have right now, which was the third plea offer, which we had negotiated with the state, is the lowest the state will go. And I think you can recall from the last pretrial hearing where Ms. Curry was present, she put that on the record that this is the final offer that the state is willing to present to Mr. Lennox. And at this point, I told Mr. Lennox that I'm not sure if I can get anything lower than this if you reject this offer. And you certainly have a right to trial, but this is the last plea offer the state is willing to extend to you at this time. And I've tried to ask him any questions that he has. I've addressed those as well as I can. So if he's confused about anything, he can let the court know or let me know, and I could answer any question that he has.
Mr. Lennox, do you believe you need some more time today to speak with Mr. Murleader to resolve any confusion that you have?
No, sir. No, sir.
You
I understand.
Let me say this. Do you understand that Mr. Murleader, as your attorney, cannot make the state give you a certain offer? It's the state's case. The state can extend any offer or no offer. And even I, as the court, could not tell the state that they had to make you an offer. And I, as the court, could not even tell them that they would have to submit a certain offer. That is entirely up to the state of Texas, to the prosecutors. Do you understand that?
Yes, sir. Yes, sir. I apologize.
So Mr. Murleader is not in a position, nor am I, to put you in a position to where you can ask for less. If the state of Texas says that the offer that you are going to agree to today or have agreed to is the best that it's going to get, then that's all Mr. Murleader can do. You understand that?
Yes, sir, I do. Yes, sir.
Is there any other confusion that you have?
No, sir, there is one.
Because if there is, Mr. Lennox, I want to make sure that we talk about this today. I don't want you and I to leave this hearing and you be wondering what if, and if you had the opportunity to ask. So I want to make sure that you understand completely, 100% what you're doing and why you're doing it, and what the outcome is going to be of your decisions today.
Yes, sir.
Do you have any questions or any issues that we need to talk about before we go any further?
No, sir. No more confusions, no more questions. I'm perfectly ready to proceed.
Okay. Mr. Murleader, you've answered a lot of my questions in this next question I was going to ask, but you have explained all of Mr. Lennox's legal and constitutional rights to him, have you not?
Yes, Your Honor, I have.
And you believe him to be competent today?
Yes, Your Honor, I do.
Have you seen any issues related to any of his mental health disorders impacting his ability to be competent and rationally understand these proceedings?
No, Your Honor. I believe him to be completely competent, and I have requested those mental health records, and I filed them into our case under business records affidavit. But I do not believe that they're affecting his ability to take a plea.
All right, thank you. Now, let me ask counsel. I see on my docket that it says it's a first-degree felony offense of aggravated sexual assault of a child. Mr. Murleader, you mentioned continuous sexual abuse of a child, and in the plea papers it says plea of guilty to the lesser included aggravated sexual assault of a child.
That's
So
correct.
was he indicted as an aggravated sexual assault of a child?
No, Your Honor. He was indicted for continuous sexual abuse of a child under Section 21.02 of the Texas Penal Code. The state has offered to remove that and offer him 20 years under aggravated, which he has accepted.
Okay, all right. So, Mr. Lennox, you were indicted by the Van Zandt County Grand Jury with the first-degree felony offense of continuous sexual abuse of a child. That offense carries a range of punishment of not less than 25 years or more than 99 years or life confinement in the Texas Department of Criminal Justice Institutional Division. Now, the agreement that you've reached with the state is a reduction of charge to a first-degree felony offense, aggravated sexual assault of a child, with a range of punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice Institutional Division. So it appears to the court, Mr. Lennox, that the state has reduced their charge from a minimum 25 years to that of a minimum of 5 years, and they're recommending 5 years less than the former minimum that you had. Does that make sense?
Yes, sir.
Now, I need to ask you, do you understand that full range of punishment of not less than 5 years or more than 99 years or life?
Yes, sir.
And also a fine not to exceed $10,000. Now, it appears that the agreement is that you would plead guilty to that first-degree felony offense of aggravated sexual assault of a child in exchange for the state's recommendation that your punishment be assessed at 20 years confinement in the Texas Department of Criminal Justice with a 0 fine plus court costs of $290 reimbursement of $20, and you would receive 218 days credit for time that you have already served toward this sentence. Do you understand that? Is that your understanding of the plea agreement?
Yes, sir. That's correct, Your Honor.
So let me ask at this time, Mr. Lennox, how do you plead to the first-degree felony offense of aggravated sexual assault of a child alleged to have occurred on May 10th, 2020? Do you plead guilty or not guilty?
Guilty, sir.
And Mr. Lennox, are you pleading guilty of that offense because you did commit that offense?
Yes, sir.
And has anyone threatened you, forced you, pressured you, or otherwise made you feel like you had to plead guilty to that offense?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Murleader, any objection to State's Exhibit 1, the stipulation of evidence? Mr. Murleader?
No, Your Honor. I thought you were going to ask for any additional exhibits.
No. All right, so the court hereby admits State's Exhibit 1, the stipulation of evidence, and takes judicial notice of Mr. Lennox's judicial confession. Is there anything further from the state?
Your Honor, I did provide to Ms. Barker prior to court this afternoon the victim impact statement in this case. Has the court had an opportunity to review that?
The court has, and I have the document here with me.
Okay, very good. In that case, Judge, nothing else from the state. We rest and close.
Mr. Murleader, anything on behalf of the defense?
Yes, Your Honor. In addition to waiving his right to trial and waiving his right to appeal, I've also counseled Mr. Lennox on his lifetime requirement of registering as a sex offender under Chapter 62 of the Code of Criminal Procedure. With this case being potentially being parole eligible, if he is released on parole, he'll have to immediately report to the local law enforcement or register as a sex offender. And I've counseled him on that, and those pleadings and confirmations were provided to the court as well.
Thank you, Mr. Murleader. I'm going to take a moment and review the stipulation of evidence. All right, Mr. Lennox, based on the evidence presented to the court will find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement and the recommendation of the state. The court hereby convicts you of the first-degree felony offense of aggravated sexual assault of a child. The court assesses your punishment at 20 years confinement in the Texas Department of Criminal Justice. Court assesses a zero fine, $290 court costs, orders you to pay $20 reimbursement fees. The court awards you 218 days credit for the time that you have spent in jail. on this cause. The court finds that you have this day been prosecuted and convicted of an offense under Chapter 62 requiring your registration as a sex offender for life. Court acknowledges that you have been provided a copy of Chapter 62 of the Texas Code of Criminal Procedure. Mr. Lennox, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of your sentence. You can step to your left to be fingerprinted with the bailiff.
Judge, that's all I have for the court this afternoon. May I be excused?
Yes, Mr. Murray Leader, and I believe, Mr. Murray Leader, is your original billing there with you, or?
No, I submitted it along with the paperwork to Ms. Abraham. The only thing with us right now is just the judgment, which Mr. Lennox will get a fingerprint on.
Okay, great, thank you. I'll get that processed.
Who's in next?
Okay.
Start with Mr. Rice. We'll get Mr. Autry.
Okay.
Just 1 second, Mr. White. All right, Mr. White, who do you have with you?
Your Honor, I've got, Abram Rice.
CR 2306, CR 1965, State versus Abram, Hastings Rice III. Show that we're set for arraignment on the aggravated assault, family member, household member, and also a motion to revoke on the arson. Go ahead.
Your Honor, at this time, we'll waive formal reading of the indictment, indicate that his name is spelled correctly. We know what we've been charged with. At this time, we'll enter a plea of not guilty.
All right, the court will enter Mr. Rice's plea of not guilty into the record in CR 2306. Are you wanting these cases to run at the same time, Mr. White?
Yes, sir.
And state, do you have any objection to the motion to revoke being reset?
No, Your Honor.
All right, court will set Mr. Rice then for pretrial and hearing on the motion to revoke on February 9th.
That's all we have, Your Honor.
All right, thank you, Mr. Roy. Mr. Rice, we'll see you back on February 9th.
Mr. White, are you ready for Mr. Autry?
Your Honor, I've got another case I can take up. We're waiting on some paperwork on Mr. Autry.
Waiting on paperwork for who?
Mr. Autry, Your Honor, we're gonna plead him out this afternoon.
Okay.
I do have Cody Pickett.
Mr. Pickett is in Tarrant County, is that correct?
Yes, sir. As of this morning, I contacted Ms. Taylor again, his Tarrant County attorney. I got a hold of her office. I'm going to assume it was her assistant. He checked and said that they were still showing him in custody. Given the fact that he's got a hold from here, I have no doubt that that's correct. He's been in there for quite some time.
All right, then the court will carry forward the status of Mr. Pickett in 2017-410 and CR 17-107. We'll set those on February 9th for a status. Does the state have any additional information?
Judge, I'm relying on the information we're getting from Mr. White, but I have no reason to doubt that.
Well, the court has verified that he is in the Greenberg unit at Tarrant County.
I need to speak to you, sir. Your Honor, may I mute the camera for a moment, please?
Not if I do it for you.
Judge Martin,
Yes, ma'am.
it appears that Mr. White's going to take some time to get his paperwork done. Meanwhile, I notice the only ones waiting besides our 3 o'clock appointment are 2 Zoom attorneys, Mr. Weiner and Mr. Adams. Are they both with you that we could go ahead and bring their clients up?
Yes, I told them I was going to bring them in until their clients were ready.
Very good. Then that's what we'll do.
Whoever you bring up, then let me know who it is, and I'll bring the attorney in.
Thank you, sir.
I know that proceedings are supposed to be secret.
Bailiff, who do we have here?
This is Mr. Pritchett, Christian Pritchett.
All right, let me bring Mr. Weiner in. All right, good afternoon, Mr. Weiner.
Good afternoon, Judge. I was sitting patiently in front of my computer, and then like the 2 minutes I stepped out to get some coffee. I apologize.
That's the way it happens. All right, this is CR 19-153, State versus Christian Cecil Pritchett, set for hearing on his motion to adjudicate.
Yes, Your Honor. I've spoken with Mr. Cox. The primary allegation in the motion to proceed is a new offense for which the DA's office is not. They have not been able to secure the offense report. So neither side is prepared to move forward on this. I did speak with Mr. Cox, and we did come to an agreement for a PR bond for my client. He has signed off on an agreed order of that nature, and I e-filed it about 1:30 right before I hopped on the Zoom. I don't know that it's been accepted.
I have a physical printout, but you said you've also e-filed it.
Yes, Your Honor. That's perfect.
And what's the alleged charge that Mr. Pritchett is facing in his motion?
He's on a deferred probation for a burglary of a habitation, and the allegation is another burglary of a habitation. I have spoken with Pat Jordan, as you're aware, constable out there, who was able to give some insight into kind of the validity of the charges and pass that information along to the state.
Should I be concerned with Mr. Pritchett to the degree I need to put a GPS on him?
Respectfully, Mr. Pritchett, I only vouch for myself, but I don't believe that there were any other issues while he was on probation except for this. I don't think there were any problems with urinalysis or not reporting or anything like that. I believe he's worked faithfully. I can tell the court that he does have a good support system. He has friends and a sister who kind of scraped up as many pennies as they could to hire me and are there for every court setting. So I know he's got a good support group as well.
All right, court will reset Mr. Pritchett's hearing on his motion to adjudicate. We'll set this on February 9th. Court will grant the agreed order on personal bond. It's a $1,500 personal bond, is that correct?
Yes, Your Honor.
And this was a motion, is this a motion to revoke or a motion to adjudicate?
It's a motion to proceed on adjudication, Judge. And he had a bond. We were set last month for the first time, and there was an agreed reduction. And obviously because the law enforcement agencies not turning over the report, that's why there's an agreement in this case.
All right, the court has signed the $1,500 personal bond order. The court will not require Mr. Pritchett to be affixed with a GPS tracking device this time. However, the court will know that if Mr. Pritchett picks up a new charge while he is out, that the court will ultimately get to hear the motion to adjudicate. You understand, Mr. Pritchett?
Yes, Your Honor.
So I'm going to go along with Mr. Weiner and Mr. Cox here, and we're going to allow you to get out. Sure would be really bad for you if you were to pick up another charge while the court has been gracious enough to let you out here a few days before Christmas. You understand?
Yes, Your Honor.
I mean, it'd be real bad for you. I don't know if I can stress that enough. You understand?
Oh, I understand.
I know Mr. Weiner understands, and I'm sure he's going to communicate that to you as well, but I don't want this to be coming back and asking for mercy because there probably won't be any. You understand?
I understand 100%.
All right. Court will have that order sent over to the Justice Center, and we'll see you back on February 9th. And when you're on bail, it'll be at 9 a.m., Mr. Pritchett.
Yes, Your Honor.
Thank you, Judge. That's all I have. May I be excused?
Yes, thank you, Mr. Weiner.
Thank you. Merry Christmas. Merry Christmas, Hillary. Good luck with the wedding.
Phil's brother is. Hillary, you're getting married?
Just for the record, my brother's wedding. I'm still single.
There was a lot of confusion over here as to whether or not Hillary was getting married.
You didn't tell anyone.
Bailiff?
Yes, Your Honor.
I'm going to see if Mr. Garcia is ready in Galveston County. I'm going to go ahead and try to bring him in at this time and get an update. I feel like me and Mr. Garcia are pen pals now. I've never had a pen pal in prison, but I feel like this is as close as I'm going to get. So I'm going to see if he's available. Well,
Yes.
well, he's not available yet. It doesn't look like. As soon as he zooms in, I'm gonna bring him in.
Yes, sir.
All right, thanks.
Mr. Adams is your attorney? Yes, ma'am. Okay, he's gonna be joining us via Zoom.
Mr. Adams, are you ready for Ms. Savannah Toon?
Yes, Your Honor, I'm ready.
All right, court call CR 2230-231, State versus Savannah Michelle Toon. Sure that we're set for pretrial on each one of her cases today?
Correct, Your Honor. And I don't have any pretrial pleadings on file yet. I have some discovery issues. First and foremost is that I have several hours of video footage, recorded witness interviews to go through, including the normal body cam footage. I've begun going through that, but I still have a ways to go. And it won't be, of course, until I finish going through everything that I'll have a better handle on what needs to be done on our end for pretrial purposes. I also don't have there's no plea offer yet from the state. I don't know. I don't think that they're holding out on me yet. I don't have one yet. And then I have a couple of issues with viewability of some of the video footage that I have received so far. In other words, I've got some footage that is not cooperating with my hardware, and I need to get that addressed with the DA's office to get duplicates, or to go over there and look at what I can't see here in my office. Mr. Cox advised myself and Mr. Ashmore about 2 weeks ago that there was some additional supplemental discovery materials that were going to be furnished to Mr. Ashmore and myself. Mr. Ashmore represents Mr. Taylor, the co-defendant. I don't have those materials yet, but I intend to swing by the DA's office tomorrow to pick it up. And then, of course, after going through all the video footage and receiving a plea offer, I'll need to visit with my client so that she can review all those materials with me, and we can talk about what to do with her case in the context of the state's plea offer.
State, do you have any objection to Mr. Adams' request for an additional setting on pretrial?
No, Judge, I would just point out though, with regards to the, I guess, for lack of a better word, the extraneous information that I made Mr. Adams and Mr. Ashmore aware of, that's all information that was emailed to me, and I have forwarded all of that to Mr. Adams and Mr. Ashmore both. So they have everything I have as far as that information from a third party.
Okay. All right. Danny, I didn't realize that. I'll go back and look through my emails. If I can't find it, I might have to bother you to forward it to me again. I hope that won't be too big a problem.
No problem.
Okay. I'll go back and look and let you know by the end of the day.
Okay.
All right, then the court will set Ms. Toon for pretrial on February 9th, 1:30 if she's in jail, 9 a.m. if she's on bail.
All right. And I would, if with the court's indulgence, Your Honor, I would like to let Ms. Toon know that she and I will be visiting this week. We haven't had an in-person conversation since our last court date, and I want to reassure her that she'll see me this week.
Did you hear that, Ms. Toon?
Yes, sir.
Okay.
Your Honor, Deputy Schaffner is just bringing to my attention that she's housed in Henderson County, so that's going to be an arrangement that we'll need to make, or Mr. Adams will need to make.
Thank you for telling me. I appreciate that.
Yes, sir.
Okay, Ms. Toon, Mr. Adams said he'll come and he'll see you this week.
Okay.
All right, we'll see you back on February 9th.
Okay, thank you. We'll go with my partner. Right, and the judge is aware of that. Are we gonna bring the other guy just to have him sit in there?
All right.
All right, thank you.
I signed it.
Hell, I don't know.
I don't know either. Yep, I have.
Make sure I signed everywhere. I'm pretty good about not signing stuff.
Judge, what February court date was that for Ms. Toon?
February 9th.
February 9. Okay, thank you.
Do you have any scheduling issues on that day?
That far out, I seriously doubt it.
Well, let me
No,
see.
I'm wide open. That'll be fine.
I'll try to create some. Bailiff, do we have Mr. Williams on his way up?
Yes, sir. That's what I'm being told.
road and driving and gone, and Christmas just ain't fun no more.
Mm-hmm. Hello, y'all. I have Mr. Garcia being brought down here as we speak, so it'll be just about a minute.
Thank you, sir.
Nah, he's putting it down.
Well, right now,
He's just down the long hallway, so.
all we do now is we buy gift cards and mail them to them.
Yeah. I hear you.
Hey, how you doing there?
Mr. Garcia, how are you, sir?
So you done grew your beard over there.
That's right, man. I'm waiting on you, man. It's been a couple months, so I figured I'd just grow it out while I was waiting for you to get up here to Van Zandt County. All right, this is cause number CR 2079, State versus Daniel Ray Garcia. And we are set for arraignment again. Kind of give me an update where we're at with your case in Galveston, Mr. Garcia.
I have a disposition tomorrow, and that's going to be my third one in 2 weeks, which is kind of give me some hope that they're working on getting this finalized. So my lawyer, I spoke to him in a few weeks, 3 weeks. I've been trying to contact him here, and they made an offer. We made a counter offer, and just waiting on to see if that counter offer goes through, which would be a year county time, and I got 10 months done. So it would be, if that goes through, I'll have 2 months. As of today, I'll be out in 2 months. If they agree to that, I'll be out in February 14th. I'll be out Valentine's Day.
Okay. Who's your attorney, Mr. Garcia?
His name's Mark Aronowitz, ARONOWITZ.
The reason I ask is the state may be interested in reaching out to Mr. Arnarowitz. All right, state, do you have any objection to the court setting this in February? Seeing if we can get Mr. Garcia here to resolve his case?
Do I have any?
No, I'm asking the prosecutors here, the state of Texas.
No objection from the state, but I would love if Mr. Garcia could spell that name again for me.
Go ahead, Mr. Garcia.
Okay, miss. It's ARON, Nancy, OWITZ. I T Tom Z Zoo. Aronowitz.
Thank you.
Yeah, if you could give him a call and tell him to hurry up, that would be great.
All right, the court's going to set you, Mr. Garcia, for a status on your custody and arraignment on February 23rd, okay? February 23rd. So if you reach an agreement and you get out there on the 13th, then 10 days after that, you will come see me.
Okay.
February 23rd.
Okay, sir. What was your name, sir? I never did get you.
My name is Judge Chris Martin. You should see it on your screen there.
Yeah, Chris, that's right. Is this case going to be in your court?
Yes, sir.
Okay. And what court is this?
This is the 294th.
294th. One more question.
It's Van Zandt County.
Yes, sir. Let me see. Is there any way that just at least for right now that I could get appointed a lawyer?
If you request a court-appointed attorney and the court reviews and finds you to be indigent, it's possible.
I mean, I am indigent now. I mean, I've been here 10 months, so it's kind of depleted.
I'd be interested in getting you here. Let's get you here, and then we'll cross that bridge. When you get here, you can fill out that paperwork, and then the court could review it. And if the court finds you to be indigent, then I will appoint you an attorney, and we can resolve your case at that time. It's going to be difficult for a court-appointed attorney to meet with you if you're still in Galveston County. So let's just wait and see when you get out and when you get up here.
Okay.
Okay.
All right, sir. And what was the cause number on this? CR20
-00079.
79. All right, Mr. Martin. Well, y'all have a good holiday. Have a Merry Christmas.
Have a Merry Christmas to you as well, and we'll see you on February 23rd. Okay.
Okay. All right. Thank you, sir.
Tell the jail staff there I appreciate their help.
All right.
You're welcome, Your Honor. Y'all have a good holiday now.
Merry Christmas.
Merry Christmas.
Mr. Adams is your attorney? Mr. Adams? Is that a yes?
All right, court calls CR 19-224, CR 20-146, State versus John Charles Williams. We're set for pretrial today, Mr. Adams. I also believe there's a issue of a motion to withdraw. Is that correct, Mr. Adams?
Yes, Your Honor, that's right. I did file the motions. Unfortunately, I don't have them. I don't have file marked copies back yet, but I did forward to the court copies of what I e-filed with the district clerk's office.
What type of motions were they?
There were motions to withdraw as attorney of record, Your Honor. In the motion, I allege that that communication between myself and Mr. Williams has reached a point such that I feel as though I cannot effectively represent him going forward. And again, I'm not going to get into the specifics of the communication between Mr. Williams and myself, but it has to do with whether or not I made certain representations to him and or him making representations to me that we now believe or now that we now say we did or did not make. In the motion, I represent to the court, and I think that this is inaccurate in a detail, and I apologize, but I represented to the court that Mr. Williams on October the 13th of this year, assent or voiced his willingness or desire to have me withdraw as counsel. I don't believe that October 13 date is correct, though. After I filed the motion, I went back and rechecked my calendar, and it was a date after October 13th. I think it was at the beginning of November. And so for that particular error in the motion, I apologize. I did not intend to mislead the court as to the dates. That was simply an error of oversight on my part, and I think the date itself ultimately is immaterial to the general representations in the motion.
Okay, and did you file any pretrial motions other than your motion to withdraw regarding his cases?
I have no other pretrial motions pending right now, Your Honor. I thought that the last time that we were in court that we had reached a plea agreement, and so I was prepared the last time that we were before you to move forward with a plea of guilty and a sentencing hearing, but obviously that didn't come to pass.
And I vaguely remember an exchange regarding that. Can you remind me again, Mr. Adams, or the state, what is the offer in Mr. Williams' cases, if there is one?
It's 25 years TDC, Your Honor, which is the minimum in this case. He's a habitual felony offender, so his punishment range is 25 to 99.
Is that in each case, Mr. Cox? Or
Your Honor, I believe it is. Yes, sir.
And so, Mr. Adams, just so my clarification, you filed a motion to withdraw, and you're stating and telling the court that you believe that you and Mr. Williams can no longer effectively communicate, in which would be required to render him effective assistance of counsel.
That's correct, Your Honor. I believe that if I were to continue representing Mr. Williams, that there would be a much higher than average possibility that Mr. Williams would feel the need or desire to contest the ultimate outcome of his case by virtue of a writ, and that's just an issue that I would rather avoid. And I would like for him to have an attorney who has with whom the air is clear, so they can communicate clearly and freely with one another without having to worry about past communications and representations.
My only concern with that, Mr. Adams, is that I don't know that such attorney exists for Mr. Williams. You see, you're his second attorney, and I fear that there will be a third, and there will be a fourth, and that Mr. Williams will sit and he will languish in jail. That's my concern. Mr. Williams?
Yes, sir.
Are you going to hire an attorney to represent you?
It was in the process, Your Honor, and at this point in time, I don't know. My first attorney, that he withdrew himself because of a conflict of the person that's a potential witness in my case. He represents them also, Your Honor. So he had to withdraw, and then I got Mr. Adams, and I just don't feel that, you know, I don't think he can help me, Your Honor. I'm just looking for.
Why do you think he can't help you?
Because he told the courts that he showed me 8 videos, and he has yet shown me 1 video, much less 8, nor has he showed me anything that has, he showed me nothing other than a 25-year plea agreement. When I tried to talk to him about, you know, some things that happened leading up to this case, that, Your Honor, that some of it I don't even know why I'm in jail. And yeah, and none of that's came to light. The only thing he had was a 25-year plea agreement. That nothing's that I had to say was ever heard, and no, he has not showed me no videos, Your Honor. The jail video will show that. I mean,
all right,
Your Honor, I have, so far as I know, all the discovery that is available in this case. Mr. Williams wants to see it, I'll bring it over and show it to him.
I really don't want Mr. Adams to show me nothing, Your Honor. That, I would like to have a lawyer that's gonna work with me and not try to deceive the courts or me.
And that doesn't break my
That's
heart.
what I'm looking for, Your Honor.
All right, gentlemen. Court's going to grant Mr. Adams' motion to withdraw. The court will appoint another attorney, and I will send that information over to you, Mr. Williams.
Thank you, sir. Thank you very much.
And Your Honor, I'll be happy to pass on the contents of my file to whoever it is that's going to take my place.
Okay. And I'll have whoever that is contact you, Mr. Adams, to make that arrangement. So
Thank
what we're going to do, Mr. Williams, is I'm going to set you for pretrial on February 9th, and that will give the court time to appoint you a new attorney, and that attorney to have an opportunity to come speak with you and get caught up on the discovery and receive the discovery from Mr. Adams. And hopefully should be ready for some type of a announcement for pretrial on February 9th. Go ahead and sign that notice there that my bailiff has for you, and my criminal court coordinator will provide the new attorney information to the jail, and they will provide that to you, and it'll have an address and a phone number. You understand?
Yes, sir. Thank you very much, sir.
You're welcome. Have a good day.
Your Honor, I think that's all I have on the court's docket this afternoon. May I be excused?
Yes, thank you, Mr. Adams.
Thanks, Judge. Thanks for indulging me with the video appearance this afternoon.
You're very welcome. Are you here on Thursday?
I don't have anything on my calendar. I'll double check the court's docket though.
Okay. All right. Thanks. If I don't see you before Christmas, Merry Christmas.
Yeah, Merry Christmas, everybody. Good to see everybody.
All right. Is this Mr. Autry?
Yes, sir.
All right. And what are we doing today, Mr. White?
Your Honor, we're going to enter a plea of guilt pursuant to an agreement.
All right. You go ahead and tell me the terms of that.
The state's going to proceed on a 1244A, 4 days in jail, credit for 4 days, a fine of $4,000.
There's also restitution, Your Honor, of $180, court costs of $290, and an $85 reimbursement fee.
Yes.
No attorney's fees, Judge.
Okay. Thank you. And what you said, $4,000 fine. Is that right, Mr. White?
That's correct, Your Honor.
And let me flip back. What is Mr. T charged with possession of controlled substance?
Possession of controlled substance of less than a gram, Your Honor.
So state jail felony prosecuted under 1244A.
That's correct.
All right, Mr. Autry, raise your right hand. I'm going to place you under oath, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you put your hand down. All right, are you Mitchell Autry?
Yes, sir.
Make sure you speak up for me. I have a court reporter here with me, and she has to take down everything you say, okay?
Sure, I'm sorry. Yes, sir.
Thank you. That's much better. All right, Mr. Autry, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes, very much.
You feel like you've had enough time to review your case with him and have all your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed and that you're doing here today that you do not understand?
No, sir. It was very, he explained it very well, sir.
And you signed the documents throughout, and you would tell me, you're telling me under oath that that is your true and correct signature, and that you signed only once you understood everything that you're signing. Is that correct?
Yes, Your Honor.
All right, Mr. Autry, you are charged by indictment with a possession of a controlled substance in penalty group 1, less than 1 gram. That's a state jail felony. A state jail felony carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice State Jail Division, and a fine not to exceed $10,000. However, the plea agreement in this case would require a reduction of that charge to a prosecution under Section 1244A of the Texas Penal Code, which would mean that if the court follows the agreement, you would be convicted as a felon today, but you would be prosecuted and punished as a misdemeanor, which could mean confinement in the Van Zandt County Jail for a period not to exceed 365 days. Do you understand those ranges of punishment as I've explained them to you?
Yes, Your Honor.
Now, the agreement, as Mr. White, Mr. Cox told me, was that you're going to plead guilty and you're going to be sentenced to 4 days confinement in the county jail. You're going to receive 4 days credit for time already served. You're going to be ordered to pay a $4,000 fine, $180 restitution, $290 court cost, $85 reimbursement fee. Is that your understanding of the plea, Mr. Autry?
Yes, Your Honor.
Mr. Autry, how do you plead to that offense? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty of that offense and for no other reason?
Yes, Your Honor.
Has anyone threatened you, forced you, or pressured you to plead guilty today?
No, sir.
All right, the court accepts Mr. Autry's plea of guilt. Mr. White, any objection to State's 1 stipulation of evidence?
No, sir.
All right, court admits State's Exhibit 1 and takes judicial notice of Mr. Autry's judicial confession. Is there anything further from the state?
Not unless the court wants a brief synopsis of the facts.
I will get that in just a moment. Mr. White, anything further from the defense?
No, sir.
All right, go ahead, Mr. Cox.
Judge, this was a traffic stop for an 18-wheeler that was parked in the middle of an exit ramp off the interstate. Deputy Bridger made contact with the driver. The defendant here was a passenger in the back of the cab of the 18-wheeler. Deputy Bridger asked for consent to search from the driver. It was granted. And in the sleeping portion of the cab, he located methamphetamine, which was underneath the area where the defendant was sleeping in the cab.
And we have a lab report that confirms that it's a controlled substance.
Yes, sir. It was 3/4 of a gram.
Thank you, Mr. Cox. Mr. White, any objection to that summation?
That pretty well covers it.
All right, then based on the evidence before the court, Mr. Autry, the court will follow the plea agreement in your case. The court finds that there's sufficient evidence to convict you of this offense and does convict you of possession of a controlled substance in penalty group 1, less than 1 gram. The court assesses your punishment under section 1244A of the Texas Penal Code at 4 days confinement in the Van Zandt County Jail. The court awards 4 days credit for time already served against that sentence. The court orders you to pay a $4,000 fine, $180 restitution, $290 court costs, and reimbursement fees of $85. Mr. Autry, you need to make arrangements with the court compliance officer to begin paying the county the fines and fees and reimbursement that you owe. Your failure to do that is going to result in the court issuing a warrant for your arrest, and you're going to be right back in the Van Zandt County Justice Center. Do you understand?
Yes, Your Honor.
So as long as you're making a substantial effort and a good faith effort to discharge them, the county will continue to work with you. County has no interest in putting you in jail. You understand?
Yes, thank you, Your Honor.
All right, Mr. Autry, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Mr. Autry, I will tell you also that your bondsman in this case filed a request for a warrant to go off your bond. So that's going to be active for just a little while until the court can process the paperwork to withdraw it, okay? So you need to be careful about when you leave, if you get stopped on traffic or have any other contacts with law enforcement, that warrant may still be active for, potentially the next 24 hours, okay?
Sure.
All right, please step to your left, see my bailiff, and you can be fingerprinted, and then I want you to make contact with the court compliance officer. And bailiff, do you have Ms. LaPrad's number there with you?
Yes, Your Honor, I have a business card for her. I'll
Okay,
provide it to Mr. Autry.
Thank you, I appreciate it. All right, once you're fingerprinted, you're free to go, Mr. Autry.
Well, thank you, Your Honor.
You're welcome. Thank you, Mr. White.
Thank you, Your Honor. That's all I have. I believe I'll see you again on Thursday.
Looking forward to it.
I bet you are.
Your Honor, if it pleases the court, I have before me an habeas corpus, cause number CR 20-00101. It is an outstanding warrant, sir. Mr. Cox and I have had a discussion, and the DA's office said they're willing to just go ahead and withdraw that warrant.
You said it's a KPS profile?
It's an alias corpus, sir. Bring the ball together.
What's the individual's name?
Mitchell Autry.
Oh, Mr. Autry that was just there?
Yes, sir.
Yes, I'm gonna withdraw it. I just have to get the order signed and sent over there.
That'd be fine. Thank you, Your Honor.
You're welcome.
Yeah, he told you.
What it is, you were booked in under the charge, right?
I think he's been.
You came to jail, you were booked in 2 years.
I'm sure it was.
So you made bond, so you've been out on bond all this time. So the charge, and you're still booked into the jail, for you to be released back into the prison, we have to take all that information, fingerprint you, and then you're free.
Sure. All right, okay, well,
We're not gonna keep,
whatever it takes.
we don't want you.
You're good?
Yes, sir. You got anything on you?
Keys.
You got someone you can leave with, so they have a drag on that back there? No, I couldn't. All right.
That it?
Just a matter of me turning it over.
That it?
All right, State, I don't believe we have anything else at this time. Bailiff, are we we're not doing the extradition?
Your Honor, they've got the, no, sir, they don't have all the paperwork.
Okay, well, just let them know that if they get it and they want to do it tomorrow, then just let me know.
Okay.
I think our morning is clear. We have a couple things in the afternoon, but we'll be able to work them in anytime tomorrow if they need it.
I will extend that offer. Thank you, Your Honor.
Thank you all for your help. Appreciate it. Good luck on the wedding, Hillary. Whatever that means.